I'd like to use this opportunity and this time to speak on supporting the Murray legislation to protect women's health from interference, from corporate interference. And Madam President, because of obligations to speak in a memorial service tomorrow, I won't be able to speak tomorrow morning. And I feel so strongly about it, I'd like to have a few words today. I believe that this legislation ensures that the personal opinion of your employer doesn't trump the medical opinion of your doctor. I sure wish this legislation wasn't necessary, but unfortunately, because of a recent Supreme Court decision, now known as the Hobby Lobby decision, it is necessary. Let's talk about how we got here. Like you, Madam President, we worked on health care reform. We were so concerned that over 40 million people didn't have access to health care. We were concerned that just being a woman was treated as a pre-existing condition. We were charged double for what our insurance was. We were often had to pay significant co-payments for those things related to early detection and screening, for those things that would affect us, like mammogram care. So on a bipartisan basis, we ended that discrimination so that women couldn't be charged more than men of the same age or comparable health status. And we also wanted to be sure that we could do preventive health care benefits. Now, and that was an amendment that I offered on the Senate floor. We had a spirited debate, even with Senator Mikulski. Senator Mikulski, my colleague, we agreed on the same goals. We had different methods. Ours won, mine won. But I wanted to be sure that politicians didn't decide what was preventive health care. I wanted to be sure that politicians didn't decide what should be covered or not, and I didn't want to bring politics into it. So we turned to one of the most distinguished organizations in our government that makes recommendations to our government on health care policy. It is known as the Institute of Medicine. It is a nonpartisan group funded by this Congress, made up of scientific experts to advise us on medical and health care. And we wanted them to tell us what should be the preventive services that were included. So when you hear the criticism, some government agency decided this, some bureaucrat decided this, these are scientists, these are physicians, these are skilled researchers. And they determined that women should have access to preventive health care benefits for free. First of all, screening for gestational diabetes. That means, do you get diabetes while you're pregnant or because you're pregnant? High risk to the mother, high risk to the child. High risk HPV DNA testing. Annual counseling and screening for HIV. Comprehensive lactation support and counseling. Screening for domestic violence. And an annual well-woman preventive care visit, and a full range of FDA contraceptive methods. And that brings us to the Supreme, and that's what it was. It was the Institute of Medicine. The Institute of Medicine, not Barb Mikulski, not the Democrats, not Obama, said that the FDA-approved contraceptive methods should be available. Now that brings us to the Supreme Court and Hobby Lobby, a for-profit company employing thousands of people of different faiths and religions. Well, the Hobby Lobby owners didn't want to cover certain forms of contraception for their female employees. They said it was against their religious beliefs. And the Supreme Court said that agreed with them. Actually, the 5 men on the Supreme Court said that they didn't have to. The women on the Supreme Court offered a dissenting opinion. This ruling of the court says that the personal opinion of an employer is more important than the medical opinion of your doctor. And as the gentlelady from Wisconsin knows herself, who's put a lot of work into understanding healthcare and the delivery systems, that the use of contraceptive methods are not always used to prevent pregnancy. Some are to deal with fibroids and other medical conditions. This ruling, unfortunately, that a for-profit company can deny female employees coverage of an important preventive health care based on religious objections of a company's health care ownership or leadership team. Well, I always felt that health decisions should be made by the patient and their doctor, by a woman and her doctor, not by an employer or an insurance company. So it concerns me greatly that the Supreme Court justices decided against that. It concerns me greatly that the Supreme Court justices decided that the employer should have the power to determine what medical care is available to their female employees. This is pretty scary, actually. And I support what Supreme Court Justice Ginsburg said. What exemption does this extend? I mean, does this go to blood transfusions for some groups, antidepressants for some other groups, vaccinations to other groups? And the Supreme Court said, oh, no, it's only for this. Well, one Supreme Court decision leads to another Supreme Court decision. So Senator Murray has an architect of a bill, which I am going to co-sponsor, has led the way. Her bill does two things. It prohibits employers from denying coverage of specific health care items or services if the coverage of that item and service is required by federal law. It keeps in place, however, protections for religious organizations. So the house of worships can be exempted from this mandate of contraceptive coverage. Religious nonprofits can certify that they don't want to offer contraceptive care, and it ensures that the insurers work separately with employers. The Supreme Court decision is an attempt to deny women's access to birth control today, disguised as an effort to protect religious freedom. I'm a strong supporter of religious freedom. I stood on this floor and voted with its architect, Senator Ted Kennedy of happy memory, that we would always have this religious protection of religious organizations, their nonprofit affiliates. So I hope that we do support the Murray bill, that it follow the processes within the Senate, and it comes to our attention. And I believe that this will really go a long way to clarifying this really very important distinction between the religious freedom, particularly of religious organizations, house of worships, and the nonprofits affiliated with them. But it does not embody in a private business the rights of an individual. So, Madam President, I thank you for your attention and that of the Senate. I yield the floor.